Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Massachusetts, we're going to circle back on you now. We've had a chance to do a couple of videos about that, but in the last year, since the Bruen case came out, there has been this incredible phenomenon known as the post-Bruen tantrum. And this started with New York's Concealed Carry Improvement Act, which at the time was one of the worst pieces of legislation ever proposed. But Oregon followed up quickly with their ballot measure 114, which at that time I said was absolutely the most atrocious piece of gun control legislation I had ever read. Well, apparently, Massachusetts must have said, hold my beer, because we have a brand new piece of proposed legislation, and this one is a doozy. I'm going to only be able to go through all the bullet points on it because this one is so long. This probably will ultimately end up warranting additional videos if this thing starts gaining steam. But I need to get everyone in Massachusetts and around the country all informed about this. So let's start spending some time and start talking about when states start writing laws to imprison gun owners. Okay, so what we're talking about today is a piece of legislation kicking around in Massachusetts now called HD 4420, pushed by Speaker of the House Ron Mariano, apparently sponsored by Chairman Michael Day. Now, I have said before, I had an opportunity to spend a lot of time in Massachusetts, primarily in the Boston-Cambridge area for about 15 years straight. I was back there every summer. I love the state of Massachusetts. The town of Boston is amazing. It used to be the seat of liberty. However, when you read this legislation, you will begin to understand that the concept of liberty and freedom has long since been abandoned by the politicians in the state of Massachusetts. Now, we're going to put links for the bill as well as some other material that other people have drafted because, like I mentioned, this is a doozy, okay? This covers just about every single possible gun-grabbing scheme that one could possibly think of. Now, while the bill is called the Modernize Firearms Act, a more appropriate title should have been How to Jail Gun Owners in Massachusetts, because that is what this bill, if enacted into law, has the potential to do. Now, as I mentioned, I'm just going to go over some of the bullet points here, and we'll put links for everything down below, but you really do need to check this out. Okay, I'm going to start deep into the bill in Section 60. Did you hear that? Section 60 of the bill. Now, Massachusetts, you've been struggling with an assault weapon ban for quite some time. There were a bunch of firearms that were grandfathered in. There are other firearms, I understand, that do not quite fit into the definition of how Massachusetts defined assault weapons. Don't worry about that. Section 60 of this bill will take care of all of that. It will ban numerous makes and models of semi-automatic rifles, many of which are currently owned lawfully right now by Massachusetts residents. However, is there a grandfathering clause? No, there's not. There is not a grandfathering clause here, which means that the state of Massachusetts intends on passing laws that will make you a criminal overnight unless you surrender or destroy certain makes and models of firearms that you may lawfully own at the current time. What we're seeing now, and a lot of states have cut and pasted this from California, is what's called the single feature test, which is that if it's a semi-automatic rifle that accepts a detachable magazine and has any one of these other features, it now is defined as an assault weapon. That would be encapsulated into law in Massachusetts as well. Okay, one of the big changes is that the definition of firearm will also be amended by this bill to include many other types of items that one does not normally consider to be a firearm: BB guns, air guns, pellet guns, and stun guns as well. Oh, and not only will a receiver be considered a component, which this requires serialization because a receiver typically is considered the firearm, yes, so will the barrels. Okay, Section 48 of the bill requires mandatory registration of all firearms and feeding devices, and in addition to that, any privately made, personally made, unserialized firearm that you may have lawfully in your possession must be registered within 7 days of the enactment of this law. It will require mandatory reporting of any gun modifications that you make to your firearm. It will require an itemized list of any new components that you are adding to any of your previously registered firearms. And one of the interesting things is this seems to lack an exemption for people who may be just traveling through Massachusetts, which of course would be in violation of the Firearm Owners Protection Act of 1986, specifically the federal safe passage provisions which were drafted into that legislation. Section 54 of the bill would change your FID card now to a long gun, and also says that if you fail to report an address change within 30 days, then your long gun card would be revoked at such time. Section 55 deals primarily with FFLs, but things that are going to affect you, well, only a licensed FFL will be able to sell feeding devices or magazines. You cannot buy it in any other location unless you are a licensed dealer. In addition, if by chance you present an expired FID, long gun card, whatever they're calling you, to any FFL in the state of Massachusetts, they will be required to confiscate it and immediately alert law enforcement that they have taken possession of this expired FID card. Section 56 of the bill. Now, we saw this in Oregon Ballot Measure 114, and this is just a gigantic hurdle that is designed to ensure that people cannot empower themselves through their Second Amendment rights. This is new training requirements, because not only does it require a written test, it also requires live fire drills and a demonstration of proficiency before you would be given a card. Now, we here at Washington Gun Law, we espouse all the time that training is critical, that everyone should engage in training, and that's why we preach that we are the home of the lawful and responsible gun owner. However, there is no other constitutional right that a person has to undergo mandatory training before getting to exercise what is supposed to be that inalienable right. This, of course, creates an opportunity for the state to put up all sorts of different roadblocks as far as availability of training, availability of classroom, or financial prohibitions, so that those in marginalized communities will never be able to lawfully enjoy their right of self-preservation. Of course, there is a whole new section of educational requirements, including the lived experience of those who have suffered through gun violence, but none of the educational components, or anything in this bill for a matter of fact, appears to at all address public safety. There's a new definition for what's called a large capacity firearm, whatever the hell that means, but there's also new rules on transporting those large capacity firearms, which means at all times they must be unloaded and locked and secured in a separate case. Now, Section 57 of the bill is perhaps one of the most troubling, because it prohibits any person under the age of 15 from essentially handling any type of firearm, which means that it prohibits young people from learning about firearms through parental guidance, which is the way many people grow up in gun families. In fact, the law also would ban anyone under the age of 15 from participating in any type of sanctioned and organized shooting sport. Of course, I also mentioned there would be all sorts of new restrictions on feeding devices, high-capacity magazines, including the required registration of them and prohibition against transferring any of them. In Section 61 of the bill, it seems, although the language is really poorly written, to also mandate smart gun technology in any new firearm that's going on the market in the state of Massachusetts. So, as you can see, HD 4420 is an absolute shopping list of all of those who favor civilian disarmament, every single one of their pet projects. The folks here sponsoring this bill didn't pick a couple. They literally grabbed every single gun-grabbing wish list and put it all into one gigantic bill. Now, this thing is a long way from reaching the finish line, but I understand that there are enough votes out there in the Massachusetts state legislature to possibly make this happen. What oftentimes we see with a bill that is this big and this bad is that some amendments could be made to make it less terrible. This is a bill from its inception, which is so poorly written, so horribly ignorant to any constitutional standards, that there is not any one amendment or series of amendments that can be made to this legislation that would ever make it even remotely close to being a good idea. The bill, once again, is HD 4420. We're going to put links for all of the information down below in the description box, and we will keep our eyes on this one because this is absolutely an atrocious piece of legislation. In the meantime, if you got any other questions about that or anything else related to your Second Amendment rights, you guys should know how to contact Washington Gun Law by now. If you don't, that's okay. That information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.